There was some expectation that there would be a decision on the maintainability of the Chief Justice of Pakistan's petition. We're with me today to talk about the proceedings and where we go from here are Malik Qayyum, Counsel for the Government, and Chaudhry Aitzaz, Ahsan, Chief Counsel for the Chief Justice of Pakistan. Gentlemen, welcome to 24/7. Now, I've got, I just have a thread of a conversation, and I'd like both of you to address all the issues. And I'll start with you, Malik, but I'd like you to jump in as well. Now, how do you interpret the implications of the proceeding, of the court proceeding on the merits, without first dealing with the issue of maintainability?
My own view on the subject was that two are quite interconnected. So I even in court also while arguing I said so that it would have been better if we had argued the whole case. But at that time the judges thought that they'll hear us on merits, and to tell you the truth, I was also expecting some decision today. So it came as a little surprise to me when they said we are not making anything, because they have after all heard us for about 1 month on this issue. But it's their own discretion.
It's their discretion. So how do you feel? How do you interpret this?
First of all, let me say that it's not unusual. In very major cases in which jurisdictional issues and the power of judicial review and ouster clauses have been discussed, like the Asma Jilani case, to take a starting point, for instance. Asma Jilani's case, in Begum Nusrat Bhutto's case, in Haji Saifullah's case, in Nawaz Sharif's case, in even Zafar Ali Shah's case, ouster clauses were pleaded, and maintainability was taken as an issue by the respondent government of that day, of that time. And the court did decide, club the issues together and decide it at the end. What has happened today is not a sort of a defeat for either side, but it's not a victory that the government was pursuing. The government for a month has been arguing and continuing with this particular sort of point of view and agitating that the petition is not maintainable. Do not go into the merits. Stop and don't go into the merits. Send it to the Supreme Judicial Council. The fact that they have crossed that hurdle without having decided maintainability is something that is in a way what the government did not want. So it's not a victory for either. It's according to normal practice of the court, but it is also denying the victory that the government has pursued and sought for the last 1 month.
So does this mean that sort of a prima facie case?
No, prima facie no, but there is, I saw referred to various cases, rightly so, but there is one striking difference, which is that in this case, the whole maintainability concept was based on the plea that since a constitutional body, which is Judicial Council, is already seized of the matter, you please stay your hands and don't interfere. Probably they thought that, but if Joyce I recollects correctly, and I was a little surprised in the beginning when they said that argue maintainability first, because he is right in the sense that sometimes jurisdiction, sometimes maintainability depends upon the issues which are raised on merits. So it is one of those cases where they think that we should have done it, but my surprise is only that we should have been asked to argue it for a month, and at the end of the day, no decision. That's it.
No decision, but your strategy obviously as the government was to say that there's no maintainability, as he just said. But now that you go to the merits, is there a danger that you get into this whole sort of mudslinging, accusations flying around and things that the government doesn't want to hear are now said in court?
No, the merits also are of two kinds. I don't know what Joysa will be arguing. One are the merits, whether or not the Chief Justice has committed, whether his conduct is unbecoming of a judge or not. This is one. This, I think, will not be argued here. Merits, he means whether he has raised 13 legal points, and on those points at least, I don't see any mudslinging, except that he is arguing malafide against the president and also against the prime minister.
Well, that's serious mudslinging. That's like buckets of mud.
I don't see anything being said against the Chief Justice person in these proceedings.
What about the
Not
government?
at
Things the
least by
government
me.
may not want to hear.
Well, if the government persists with affidavits filed by people who are not parties, which are the intelligence agency officials, and if they force us to put them into the witness box, then there is a lot that is coming out.
There's a lot of mud.
No. One thing you should realize.
But that is a decision we have reserved to ourselves. I think we have a case that is strong enough. I think personally, and I've tried to establish it that even today, that the reference itself taken as such is something that was not a considered decision or a duly considered document, even document. So we may get past those hurdles.
I don't know Choice has his own strategy, but I can say that if we go into the affidavits and if we go into the factual plane, then both of us are treading on very dangerous grounds, in the sense that if he forces the generals to come into the witness box, which he can if he wants to, then that can be equally true of the Chief Justice.
Oh, we will be prepared. Absolutely.
No, man, it will be a very sad day when a Chief Justice is being cross-examined.
Well, if he files an affidavit, he's...
But he's already submitted himself to the jurisdiction
Yes,
of the court by filing the affidavit.
And by filing the affidavits, these people have also, the generals have also submitted. There is no, but personally speaking and subject to
They should stay out.
No, I don't see any much relevance of this controversy in so far as his legal points are concerned.
The credibility of a DG military intelligence would depend on a lot of other things that he does, other than just following and tailing and sort of snooping on the Chief Justice.